This is a lecture from our professional responsibility class. We're going to be talking about Model Rule 5.5, and this is part one of our discussion of this rule, which addresses the unauthorized practice of law. In this video, we're going to be talking about the provisions that say what you can and cannot do in another state where you're not licensed once you are a lawyer in your home state. So let's take a look at the rule. Section A, a lawyer shall not practice law in a jurisdiction in violation of the regulation of that legal profession in that jurisdiction or assist another in doing so. So before we move on, just a couple quick observations about the wording of this rule. Note that this is broad enough to cover a wide range of violations, including violations of other sections of the model rules. But our focus here is really on the unauthorized practice of law. This also covers assisting another in doing so, and normally that's going to mean employing someone who's not a lawyer but is pretending to be a lawyer, or having a partnership with someone who's kind of a phony lawyer or is essentially representing people as if he or she were a lawyer when they're not. Now, unauthorized practice can apply to non-lawyers who are providing legal representation. And so they're pretending to be lawyers like Newman did when he represented Kramer in traffic court in this episode of Seinfeld. Law students before they're licensed. So watch out if you are giving legal advice or drafting contracts for people or things like that while you're a student. If reports get to the Board of Law Examiners that you've already been practicing law before you had a license, that could be held against you and could create a snag for you in your bar admission. This rule can also apply to licensed attorneys who are doing legal work in other states. Let's suppose, for example, that you fall on hard times and you decide to move to another state, start life over, and you begin representing clients there, even though you're not licensed in that state. This also can apply to lawyers who continue to represent clients or take on new clients while they have a suspended license or after they've been disbarred. Now, Section B. A lawyer who is not admitted to practice in this jurisdiction shall not, 1, except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, or hold out to the public or otherwise represent that the lawyer is admitted to the practice of law in this jurisdiction. Now let's just for a moment think about what this means. Even though one incident of practicing law without a license could constitute a violation, especially for testing purposes. We're being very clear that this will definitely count as practicing law in another state if you open a satellite office in a state where you're not admitted to the bar, or you start advertising for clients in another state where you're not licensed to practice. Okay, let's go back to the rule. C. Now we're going to go through some of the kind of incidental activities that don't count as a violation. You could think of these as exceptions or things that we've clearly carved out as safe harbor or permissible activities. But these are things that are okay to do. So a lawyer admitted in another United States jurisdiction and not disbarred or suspended from practice in any jurisdiction may provide legal services on a temporary basis in this jurisdiction that, and there's going to be a few of these, but number 1, are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter. So what are we saying here? Sometimes you may have a client who has a matter in another state that they want you to handle, or let's say your client has a relative who wants you to handle, wants to become your client, but they're in another state where you're not licensed. You can partner with a lawyer or a firm in another state, and you can still do most of the legal work as long as they are actually participating in some way. And the rule doesn't say how much. And of course, this other lawyer or firm will be compensated for being local counsel for that matter. This is very common, and if you're doing it a lot, you may have a lawyer or firm that you just have an ongoing relationship with that you always use. So for example, when you have clients who have a matter before a federal agency, you have a DC firm that you always use, something like that. Okay, let's go to the next rule for provision. This is the pro hoc vici exception. You can provide legal services on a temporary basis as long as you are in good standing with your local bar, if they are in or reasonably related to a pending or potential proceeding before a tribunal in this or another jurisdiction. If the lawyer or person the lawyer is assisting is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized. So hang on a second. This is a very poorly worded or confusing verbiage here. The pro hoc vici exception is only for litigation matters. So let's say you have a client and you are a lawyer in Texas, and you have a client who has a case that has come up in California or has been removed to a federal court in another state because of forum shopping and diversity jurisdiction and things like that, and they want you to represent them. Now, the easiest way to do this is to get local counsel and partner with them, but of course, that involves paying local counsel. So maybe you want to do the case. You are going to file a motion to appear pro hoc vici, and the judge in a case has pretty broad discretion to grant or deny these motions. Normally they grant them unless there's some kind of question about your disciplinary record. So if you have a spotty history of getting in trouble with the bar, that could be grounds for saying, no, we're not going to let you do cases here. But lots of lawyers get to do this. Please note that this is a one-off case. It does not allow you to hang out a shingle and start taking in new clients or offering to represent other people that you meet while you're there doing that one case. Essentially, in practice, the judge is admitting you to practice for that state, for that case in that court. And then when it's done, your pro hoc vici appearance is over. Okay, let's go back to the rule. Are in or reasonably related to pending or potential arbitration, mediation, or other alternative dispute resolution proceeding in this or another jurisdiction, if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction where the lawyer is admitted to practice and are not services for which the forum requires pro hoc vici admission. So this is essentially the equivalent of the pro hoc vici provision, except we're applying it to ADR, to alternative dispute resolution, so arbitration, mediation, and other types of ADR phenomenon that we have with the courts. And so if you are representing a client in a case in your state and it gets referred to mediation and the mediation is taking place in another state or the arbitration is, this provision covers that. Please note though, let's go back and look at this provision for a second. Unlike pro hoc vici, this one must arise out of a matter in your home state that you're already handling where you are licensed. So it's a little more restrictive than the pro hoc vici situation. But notice that under 2, you actually have a judge who is reviewing a motion for you to appear pro hoc vici. And here, if you're availing yourself of this exception, you can just go do it as long as it meets with the requirements of the rule. Let's go to the next section. This is our catch-all provision for other incidental travel to other states on behalf of a client. So they're not within paragraph C2, that's pro hoc vici, or appearances in litigation, or C3, which is ADR, and they arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. And so I'm going to give you a few examples. Again, this is more general, but it's also a little more incidental. And it won't apply to litigation or doing appearances in other states. So first example, let's say that you have a client and you've been doing estate planning for that client, or that you are handling a bankruptcy matter or something like that, and you need to travel to another state to liquidate some of their real estate holdings. So they own some properties in another state where you're not admitted, But as part of representing clients in your home state where you're licensed, you sometimes have to go to another state and tie up some loose ends for the client legally. And that's okay because it's grounded in your practice in your home state. The same would be true if you had to travel to another state to press a claim where someone owes money to the bankruptcy estate or to the estate of a recently deceased client or something like that, and you're trying to collect on that bill so that you can settle up the estate. In addition, related to litigation, this isn't litigating the case, but let's say you have a case in your home jurisdiction and you need to travel to another state to take a witness's deposition. Maybe that witness is disabled and traveling to your state to do a deposition would be very difficult. You can go to another state, take a deposition. Please note that normally you are practicing law, right, when you're taking a deposition. So, but that otherwise might constitute practicing law in another state, but because it's merely an incidental extension or part of your representation of someone in your home state, it doesn't count as a violation, and we've specifically spelled out that that will be okay. All right, let's talk about the comments. I'm not going to focus on all of the comments because most of them, to be honest, for this rule, for Rule 5.5, merely restate the rule provisions or provide a little bit of the policy kind of goals behind the rule. If for my law students, I recommend that at least you read through the comments at least once because they could clarify the rule in your thinking or help you remember it later on. Comment 3, and there's going to be a comment later on that we talk about in the next video, spell something out that's almost a standalone rule and could be the basis for a test question. So let's talk about this. You may remember that way back when we talked about 5.5a in this video that it said that you couldn't assist another in practicing law without a license. And I said that normally that means employing somebody at your firm who's a phony lawyer, who's pretending to be a lawyer and isn't admitted. This spells out something that won't count as that. A lawyer may provide professional advice and instruction to non-lawyers whose employment requires knowledge of the law. For example, claims adjusters for insurance companies, employees of financial or commercial institutions, social workers, accountants, and persons employed in government agencies. And so just to clarify, insurance companies employ claims adjusters who go out and look at the damage to somebody's car or property and decide how much damage was done and how much it's worth under the policy and so forth. And obviously they need to know a little bit about tort law and liability and who's going to pay and burden shifting and contributory negligence and things like that. You can advise these people and you can even do training sessions for groups of them. The same is true for bank managers and brokers and financial analysts and so forth, who actually do kind of need to know what the law is so that they don't steer their clients into illegal activities inadvertently. The same could be true for government officials, right? For election officials or school administrators and superintendents and principals and so forth who are dealing with the public, and prison officials, prison wardens who are dealing with prisoners, and they need to know what the legal rights and responsibilities of all the different parties are so that they can do their job. And so they're not lawyers, but they kind of need a lawyer advising them and training them in what to do so that they can go off on their own and you're not supervising their work necessarily. And this specifically spells out that that is okay. So lawyers may also assist independent non-lawyers such as paraprofessionals who are authorized by the law of a jurisdiction to provide particular law-related services. What are we talking about? These are usually called non-lawyer advocates in things like immigration cases or certain types of family cases where we might have a child's advocate or something like that who doesn't have to be a lawyer depending on the jurisdiction and the body of law that we're working under. But they're doing work that would otherwise constitute the practice of law. It would constitute the practice of law if you did it as a lawyer. But there's a special legal provision that allows certain people to do this, and you can train and advise those people. Lastly, you may counsel non-lawyers who wish to proceed pro se. And Model Rule 6.5, by the way, spells out this very situation where you're doing like one-off counseling sessions with pro se litigants, advising them on how to represent themselves. And the model rules contemplate that, they encourage that. There's some ethics opinions about this that really spell out the parameters of what you can and can't do as a lawyer. Okay, so that brings us to the conclusion of our first video about Model Rule 5.5. I do want you to take seriously, for my law students, the issue of practicing law without a license. When I first graduated from law school and started my first job, there was another lawyer there who had come in as a lateral from another state. So she was licensed in another state. It started a few months before me. And while she was still in process of seeking to waive in to Connecticut, the state where this legal aid clinic was, the law office, the legal aid clinic, sent out this brochure or mailer as a fundraiser that said, "Meet our new lawyers." And it featured her as one of them. And she was a lawyer in another state, but wasn't admitted there yet. And this ended up becoming this big, turning into a disciplinary action. And it really wasn't her fault. And it was just an inadvertent mistake by the marketing people at the clinic. And so watch out for this. Really watch out for holding yourself out as a lawyer, or even a sort of lawyer or something like that, or saying, "I'm not a lawyer yet, but," and then going ahead and providing legal services, because this can turn into a nightmare for you when you're going through the process of getting admitted to the bar and getting your law license. Okay, so we'll save the rest for our next video, part 2 of Model Rule 5.5.